Shri Prashant Katneshwarkar sir is a practicing advocate in Bombay High Court Bench at Aurangabad with more than 27 years of practice. He holds expertise on appellate side in civil, constitutional, tenancy, and arbitration law. He is one of the most distinguished civil lawyers who is well known for his precise arguments. We are delighted to have you, sir. Before the session starts, I would like to inform all our attendees that this webinar will be followed by question and answer session. The attendees through Zoom app can post their questions in chat box available on their respective screens. Can post their questions through live chat option on YouTube. Now I request Shri Katneshwarkar sir to please start his address. Over to you, sir.
Thank you. Am I audible to you?
Yes, sir. Yes, sir. You can start.
Yes. Good morning, everyone. In this lockdown, it's a very pleasure time to meet you, at least on online or this internet Zoom app. I was asked by this Lex Discourse group that I should interact with you on some point, and they suggested that it would be better to have some discussion on section 100 of Civil Procedure Code and of substantial question of law, because this has very concern with the practicing lawyers in High Court as well as litigants. First, I express my gratitude to this Lex Discourse group. They had taken a very adventurous step to interact with students, junior colleagues, and other lawyers, including litigants, and have a discussion and understand the topics of law. More particularly, Prasad, Neha, Akshay, Vaibhav, all these young lawyers have taken efforts to come together and form this group, and therefore I express gratitude towards them for undertaking this adventurous activity. Now we'll turn to our topic, that is substantial question of law involved in second appeal and the provisions of section 100 of Civil Procedure Code. We need to look to this provision of law from bottom of the litigation, because section 100 is the last substantive appeal provided to the litigant. But when a litigant with his right goes to the court, he has his remedy in a trial court. Let us take example, because 80% of our cases are such as that if father dies or if any brother has a right in joint property or ancestral property, he normally goes to the lawyer and asks that I have a right, what should I do? We advise him to file a suit for partition. As well, in a civil court, the litigations are just like this: suit for partition, suits for specific performance, suits for declaration of title, ownership, suits for injunction. This is a normal, natural litigation in our civil courts. The pleadings are drafted considering the right of the parties, his evidence, documents. Then naturally, other side comes, files his written statement. If he is benefit of enjoying the property, he takes time to file written statement. And thereafter, if judge finds time, then at some point of time, issues are framed. Then the oral evidence, documentary evidence, and ultimately, the trial court decides the case based on facts and law involved in that case. Now, this takes about 5 to 10 years normally, as experienced by us, that these are the old matters, goes on litigating, adjournments on several counts, evidence, time of the court. It takes about these 10 years. Thereafter, matter comes in a district court. Aggrieved party has a substantive right to file appeal under section 96 in the district court. So whatever decision is rendered by trial court is subject to reconsideration of a district courts. Normally in district court also, it takes around 5 to 7 years. So total journey of litigation becomes 15 to 17 years in the trial court as well as in the district court. Now the man who got decision in his favor in both the courts or in lower appellate court is waiting for execution of his right, and therefore he is anxious to see that whatever decree he has got, he must get fruits of that decree. But there is again a provision which is a substantive provision in the Civil Procedure Code, that is section 100 of Civil Procedure Code, which says that there will be a second appeal against decision of lower appellate court in the High Court. Now, point raised is that whether this second appeal is as of right or there are limitations in filing the second appeal or consideration of second appeal. And here the question of law, substantial question of law, question of facts, all these questions crops up. Right from beginning, it appears that while drafting the Civil Procedure Code, the legislature has intention to curtail the litigation at the level of High Court, that every matter should not come to the High Court and it would be pending in High Court for several years, and so there will not be full stop to the litigation and litigation will go on. With this view, the language used in section 96, that is of a first appeal, and language used in section 100 for second appeal is different one. Earlier, that is prior to the amendment, the second appeal would lie to the High Court only on 3 grounds mentioned in that section. The first one is that if the decision of lower appellate court is contrary to law, one can understand that if any decision, if it is a contrary to law, then the appeal would lie. Second clause was that if a decision rendered by a district judge is without considering the material issue or point involved in the matter, then it would involve a substantial question of law, or the second appeal would lie against that judgment. These were the 2 grounds. And the third ground was that if there is a material defect or error in procedure, and such error or defect shall be substantial one, so that if it may possible that this material or substantial defect or error would cause in decision a substantial injustice to the litigating party, meaning thereby if there is a procedural defect in it, then if it is of a substantial character, then second appeal would lie. For example, what is the procedure? Procedure is that appeal needs to be heard by the High Court, by the lower appellate court on all the points. And if suppose material points are not framed by the court below, and that aspect has not at all been considered, then there will be material defect or error which would cause substantial injustice, and therefore the second appeal would lie. This was the position prior to 1976. The Law Commission has found that because of the provision which was existing prior to 1976, there are plethora of judgments, huge pendency in the High Court. Every matter goes to the High Court after decision of District Court, and it remains pending for years together, and therefore Law Commission decided to bring an amendment into the provisions of section 100. And now what amendment has been brought by the Law Commission is that the second appeal would lie in the High Court only if High Court is satisfied that the matter involves a substantial question of law. This was the first condition. The second subsection says that the appellant before the High Court must raise a substantial question of law in his appeal memo. The third one is that if the High Court feels that the matter involves substantial question of law, then High Court has to formulate that substantial question of law and frame it accordingly and hear the matter on substantial question of law. The third provision is that at the time of hearing, if respondent could satisfy the court that the question raised by the appellant does not involve a substantial question of law, then court can hear the respondent also and decide the matter accordingly. The fourth is that at the time of hearing of the matter, if court finds that apart from the question of law raised earlier, there involves a substantial question of law, then the court can hear and decide those substantial questions of law. So this is what the position before the amendment and after the amendment. Before the amendment, only 3 grounds were provided. If it is there, then the second appeal needs to be considered. After amendment, a procedure is prescribed that what should be drafted, what should be formulated, who should draft, he should formulate. And only one word is used, that if High Court is satisfied that there involves a substantial question of law, then and then only second appeal needs to be heard, considered and decided. This is what the provision of law prior to amendment and after amendment. Now in court, when we argue the matter, we go through our pleadings and evidence, and we find that the trial court has committed this mistake, same mistake has been considered or repeated by the lower appellate court, and therefore I have a case to argue the matter, and accordingly we argue before the court. The court, of course, objects our hearing on the ground that whatever you are arguing is not a substantial question of law. The court has, both the courts have considered this aspect of the matter. Your case doesn't have substantial question of law. Or otherwise, when appellant argue the matter, court finds that this is XYZ is a substantial question of law, and therefore the respondent, suppose we are for respondent, we argue that no, both the courts have considered this aspect of the matter, there is evidence, there is a decision. Rightly, some paragraphs of the judgment of courts below may be erroneous, may be properly not worded, but that doesn't mean that there is a serious effect on the decision of the court, and therefore it need not be interfered. This is not a substantial question of law. This is what, in fact, arguments goes in the court. Now the question involved is, what is mean by substantial question of law? Appellant says this involves substantial question of law. The respondent says this doesn't involve substantial question of the court. In its discretion, as per understanding of the court and perception, says that it is substantial question of law or not a substantial question of law. Even matter if changes or seating changes, assignment changes, a question raised for a particular judge may be a substantial question of law. For another judge, it may not be a substantial. This is what the difficulty we always face in the court. So one must go to the root of the matter to understand that what is mean by substantial question of law. Now, what is mean by substantial question of law was under consideration in main 3 judgments, rather say in 2 judgments. First judgment is of Shri Raghunath Singh versus the Deputy Commissioner, that was decided by Privy Council in 1927. The question raised was that a man, namely Raghunath Singh, was having certain rights based on a document, namely will. The shares are to be determined on the basis of will. And for that purpose, he goes to the court. Court decides against him. The appellate court confirms his judgment. The Awadh court, which is the lower appellate court at the relevant time in parallel system, says that you have no case. I am confirming the judgment of the trial court, as there is no question of law involved as per provisions of previous section 100. Your case needs dismissal. Accordingly, case comes to be dismissed. Thereafter, as per old provision under section 110 of CPC at then was, if one wants to approach to higher court, that is the Privy Council, then he must apply to the court and he should request the court to grant a certificate that his case involves substantial question of law. And if it is given, such certificate is given by the lower appellate court or the Awadh court, then it will go to the Privy Council. But in his case, the old additional judicial officer has held that his case, the substantial question of law means it should be of a so importance that it is of a general importance and it should be of a public importance. Then and then only it is a substantial question of law. And since this case is not covered under the provisions what is substantial question of law, he could not get the certificate. Therefore, he approached to Privy Council. Before the Privy Council, the argument was that the question of law raised should be of general importance, of a public importance, or it should affect the right of the litigants in between the parties. The defendant's lawyer who was in that case considered to the fact that if a question of law decides the rights of the parties, then it is a substantial question of law in that case. And this view has been accepted by Privy Council in 1927. That went on for several years. That meaning thereby a question of law involved in the matter between the parties and affects the right of the parties substantially, then it is a substantial question of law. This was accepted definition for several years. Thereafter, in several high courts, different views are being taken and they started interpreting what is meant by substantial question of law. And they have created several questions, that is a question of fact, whether it involves a substantial question of law, a mixed question of law and fact, a pure question of fact, a common question of fact, and whether all these questions are substantial questions of law. That was a debate. Several judgments came, different view. Bombay view is a different, Nagpur view, that is the middle India portion, view was different, Calcutta was different, Madras was different, all were, even that benches also, those benches also taken different view in different cases. A case was filed before the Bombay High Court by one man, namely Sir Chunilal Mehta. His case was that on the basis of interpretation of clauses of agreement, he is entitled for 26 lakhs of rupees as damage, and he filed a suit for recovery of amount. That suit came to be dismissed. Matter went before lower appellate court, that is also dismissed. A learned single judge of the Bombay High Court, before whom the matter came, he confirmed the decision of lower appellate court. Thereafter, Chunilal Mehta files an application for certificate under section 110. At the relevant time it was, now it is deleted. Certificate that his case involves substantial question of law. That application came to be rejected by a single judge of the Bombay High Court, and as such matter came before the Supreme Court. So this is the second judgment which has an important bearing on a Supreme Court on a decision of substantial question of law, reported in 1951, titled as the Sir Chunilal Mehta case. This case was placed before the Supreme Court, and Supreme Court thought it fit that the case needs to be considered by the Constitution Bench judgment. 5 judges were given a task to decide what is the meaning of substantial question of law. This was the basic question which was put before the Supreme Court. Justice Mudolkar, though junior most in that bench, one of the finest judges of our Supreme Court, has delivered in that judgment. And while delivering that judgment before the Supreme Court, Constitution Bench Court, there were 4 decisions. One is of 1927 Privy Council judgment. Secondly, the judgment of the Bombay High Court, against which the matter cropped up before the Constitution Bench. Third is the decision of Nagpur Bench, and fourth is of Madras High Court, a full bench decision. Now we will deal, as far as first case is concerned, Privy Council have explained the facts of that case, and as if substantial question discussed in that. Now this Chunilal case, when it was before the Bombay High Court, the Bombay High Court did not refer to the ratio laid down in respect of substantial question of law before the Privy Council, but has referred Privy Council and has deduced in such a fashion that Privy Council decision gives guideline only, and it makes it clear that a question of general importance or public importance is not of value, because if it is between a parties and if it is a question of law, then it would be a substantial question of law. However, in a case before that, Bombay High Court, it was that interpretation of a decree was there, and therefore the interpretation of a complicated decree does not involve substantial question of law, and on that ground the matter was dismissed. However, the Supreme Court has said that if there is an interpretation, there is a requirement of deliberation on a decree passed by the court below, then it requires a consideration, and therefore the Bombay High Court judgment was set aside. The Bombay High Court has taken also a view while observing that what is a substantial question of law. It has observed that if a question of law creates a doubt in the mind of the judge, then it is a substantial question of law. This was a new thing added about the Bombay High Court while deciding this. And on facts also, since it is a complicated case, but since it is based on a decree itself, inference has to be drawn from a decree which does not involve substantial question of law. On these views, this was decided. The Constitution Bench criticized this judgment and has not accepted this judgment. The second judgment before the Constitution Bench was the decision of a Nagpur court in case of one Dattaram. And in that case, Chief Justice Bose, as this at the relevant time he has observed that the case, if another view is made applicable to the case, and if it is possible, if there are a divergent views possible, even application of law is looked from another angle, then if there is a change in the decision, then it would involve a substantial question of law. For example, if we are scrutinizing a judgment of lower appellate court, and we feel that if this evidence is read in such a fashion that it would be possible to take another view, then it involves substantial question of law. Justice Bose has also observed that howsoever absurd the pleading and the law involved in it. If it is arguable, debatable, and second view is possible in it, then also it involves substantial question of law. So both the cases, the view taken by Bombay High Court and Nagpur High Court is diagonally opposite to each other. Bombay High Court is very narrow view. Nagpur High Court is very wide, too wide, open view. Anything that can be considered in the High Court. And therefore, these two views were under consideration, and the Constitution Bench was not in agreement in both of these views. The third view was before the Supreme Court, and that was the Madras view. Madras view was somewhat, has obtained a golden mean of it. It's a very clear and possible argument was accepted by Madras High Court. And in fact, we day in and day out argue on those points. What Madras High Court says, that if a point is fairly arguable before the High Court on the basis of judgments of courts below, it involves substantial question of law. The another expression of Madras High Court is that if there is, after considering the evidence, there is a divergence of opinion in between the court, or in points made out to that effect, that two views, divergent views as possible, then it is a substantial question of law. The third is that while hearing the appeal, if the High Court considers that there is a debatable question, it requires a consideration and hearing at length, and a detailed opinion needs to be formed, what the lower courts have done, then in such circumstances, there it involves a substantial question of law. So if we consider all these aspects of the provisions of law, the judgments of the Supreme Court, then it is very clear that what is substantial question of law, it should be debatable, it should be arguable, there should be difference of opinions. The court needs, or court feels that it needs to be considered in detail, then all these points are substantial question of law. There can't be a straight-jacket formula that purely this is a question of fact, this is a question of law, and this is a substantial question of law. The question of law, question of facts, which seriously affects the rights of the parties, involves substantial question of law. And that's where we fall back to 1927 Privy Council. This is what the situation is. After the amendment, there was no decision of a court independently, ignoring the decision of Privy Council and Chunilal Mehta's case. That is the Constitution Bench judgment. Whenever a question came up before the Supreme Court to decide what is substantial question of law, normally it is found that all the courts lay their hands on these two decisions. So what is achieved by the amendment of 1976, the Law Commission's intention was to control the litigation in the High Court, to bring full stop to the litigation, that a litigant must get his substantive right decided by both the courts below and should enjoy the fruits of decree. Practically speaking, a simple suit right from partition, specific performance, injunction, declaration in our territory with advent of this infrastructural facilities, every suit comes to the High Court. High Court is burdened with huge cases of second appeal, though it may be pending for admission and pending for final hearing. 20 years, 2 decades, the matters are pending in the High Court where we practice. and more 20 years or 15 years in a courts below. So the ultimate result is that a litigant is not getting justice for around 30 to 35 years in his lifetime. And therefore, this entire system needs to be considered from all these point of view. That is what is exact legal position in respect of substantial question of law, because we also are anxious to see that our client should get justice by dismissing the second appeal. At the same time, we are anxious to see that courts below have not properly considered case of our case. So High Court should consider it. And at the same time, the court also wants to see that most of the matters should be decided at the earliest so that there should be substantive justice. Intention of the legislature is that there should be curtailment of deciding or entertaining the second appeal. From all point of views, all four corners, if we look into this case, then there needs to be substantive efforts. So far as there is hierarchy of jurisdiction, that is, there is a substantive provision of appeal from the decision of lower court to High Court, the matter is bound to come in High Court. In any way you try to curtail the litigation, it would not be curtailed unless and until we assure that district court will be the last court for deciding the matter. Whenever you open a door for second appeal, then High Court is bound to look into the matter. The lawyers are bound to argue the questions involved in the matter, and there would be hearing of second appeal in the High Court. From this angle of the matter, legislature, if really wanted to curtail the litigation, ought to have defined the word substantial question of law. Though amendment was done in 1976, which actually came into existence from 22nd of February 1977, the confusion which was already in the minds of the court in different benches was there, still it existed, and we have to face this litigation in this state of affairs. For example, procedural defect. Now, substantial procedural defect. And what is the normal procedural defect? Two glaring examples I will put before you. One is that in a lower appellate court and a trial court, my matter is entirely considered, properly discussed. But while framing the point for consideration as expected under Order 41, under 43, the court has not framed points for consideration and frames only one question, that whether trial court was just and proper in deciding the matter. Now, there are two technical aspects in the matter. Merely non-framing of issue, according to me, does not involve substantial question of law. Because if in a judgment he adverse to the point raised in the matter and considers the evidence, pleadings of both the parties and gives decision, then there is a just and proper decision of lower appellate court, what is expected of his duty. And therefore, non-framing of particular point in particular words would not be a substantial procedural defect. But many a times, because of one judgment of Justice Jagirdar that there is no point framed, several second appeals came to be admitted and are pending for final decision. If after 20 years it is found that this has to be done, the matter will go back to the district court and then again will come back to the High Court. So this is what the litigation will be prolonged, and that will be a kind of mockery of justice which the litigant expects. Second aspect of non-framing of point, what is of substantial character? If my suit is based on a particular document, procedure at appellate stage is provided that you can file a document even at appellate stage also. And if that the document is not accepted by the lower appellate court, then probably substantial question of law will involve by not following the proper procedure. It is a procedural defect that you have not filed this document at earlier stage, whatever reasons, justifiable or not. That is, but if a man has a document of a title in his hand, he comes to the court and you preclude him from submitting that, you can't say that this is a procedural error and therefore we will not entertain his second appeal on this aspect. The second appeal, the question of law which affects the right of the parties is a substantial question of law. And therefore, such procedural defects may look to be procedural one, but those goes to the root of the matter, and therefore, this is substantial question of law. This is for example, I discussed with you. Such are the cases. Supreme Court has taken several different views. That is, that if you derive a conclusion from a proved fact, and that conclusion itself is a wrong, palpably wrong, then it involves substantial question of law. Now, if we look into this decision, then we will find that this is a mere question of fact. A set of fact is before the court, and second view is possible for that purpose, but ultimately he decides on a fact. But if the learned judge derives a conclusion wrongly from a proved facts, then this involves a substantial question of law. That is what one of the Supreme Court says. In case of Santosh Hazari, the court has taken review of all the judgments, including Privy Council decision, Chunilal Mehta's decision, and has finally concluded that if obligation cast on the district court to do a particular thing in a particular way, that is all procedural aspect, and he fails in doing so, then that involves substantial question of law. Plethora of judgments. Some of the few of the Supreme Court judgments says that if there is interpretation, question of interpretation, or question of construction of document is involved, it is a substantial question of law. And for that purpose also, second appeal needs to be admitted. Now, another point for consideration, this is up to High Court, we day in and day out what we argue. In many cases, the High Court judge did not frame the substantial question of law, but decides the matter in its entirety by considering all the facts and gives a decision. Several matters went to the Supreme Court. When matter went to Supreme Court framed a point that High Court has not framed particular question of law as a substantial question of law. The matter came back. Now, what is the job of High Court to again frame it, though it is discussed and decided? Formally, it has to again frame the question of law and substantial question of law and decide it is the same, and the matter should proceed further. Several matters went to the Supreme Court. Several matters came back from the Supreme Court. Again, the matters are open, are heard, and decided all these aspects of the matter. And therefore, my perception to substantial question of law, that we should read only two judgments, that is Privy Council in Raghunath Singh judgments and Constitution Bench judgment of Sir Chunilal Mehta's case. And if we read these two judgments, we did not read other judgments because all other judgments have considered this. And if any divergent view is taken by any decision in a Supreme Court or High Court, since Sir Chunilal Mehta's case is a Constitution Bench judgment, it has a binding effect on the courts, and it should be accepted. I suppose Now there is another question which is now being considered in High Court, that one of the Supreme Court judgment is there. We cannot criticize the Supreme Court judgment, but at the same time we can argue, or we can say what is just and probable as per our perception. Now one of the Supreme Court judgment says that whenever matter come up before the High Court, it should frame immediately the substantial question of law. And if there is no substantial question of law involved, it will be dismissed. And unless and until it involves a substantial question of law, the High Court is denuded of authority to grant any interim relief. So interim relief cannot be granted before High Court constitutes or frames a substantial question of law. This is what the Supreme Court decision is. But in my practice, for last 20 years in a High Court, this law is not made acceptable, or the court never adhere this law strictly. Because question of law, if framed in absence of respondent, then it would cause harm to the respondent itself. Because many of facts which is within knowledge of respondent would not surface before the court, because appellate advocate would not argue the points in favor of respondents. So to counter that argument, respondent needs to be heard, and by that time a protection can be granted. Even section 100 does not speak anywhere that High Court cannot pass or preclude it from passing any interim order protecting the rights of parties till the question of law or substantial question of law is finally framed by the court. So the word hearing is used in section 100, that is at the time of hearing or during the hearing, the respondent can point out to the court that the question raised by the appellant does not involve a substantial question of law. This is a right with respondent. He can argue it by way of caveat, by remaining present at the time of hearing of the matter, and even after issuance of notice at the time of hearing of admission. So the High Court needs to be considered of the fact that while framing the substantial question of law, one must give due respect to the right of respondent, and therefore, according to me, while framing the question, both the parties should be heard even for preliminary hearing, that is for the purpose of framing of question of law. Considering all these views, it's a vast subject, several judgments. I tried to conclude in order to understand that what is the substantial question of law. And according to me, unless and until it is specifically defined in the code itself, we have to lay our hands in the decisions of the Supreme Court. And as we know, the Supreme Court has also says, and even there are several judgments, that there are divergent views on this point. So we must stick up ourselves to the decision of Privy Council interpreting substantial question of law. We must stick up ourselves to the Constitution Bench judgment delivered by Justice Mudolkar, and we should argue in the court on a debatable, arguable, important question of law which affects the substantive right of the litigating party. This is what I say. I have seen many questions, but while delivering my conversation, I could not read that. So any question, any proposed question that can be asked in this session for question and answer.
Thank you so much, sir, for your enlightening address. We have some questions from our attendees, which are as follows. So, the first question is, while understanding a substantial question of law, does the discretionary power of High Court overpower the interpretation of code?
Very important question. In fact, it was in my lecture itself that it is the judge's mind setup. As we practice in High Court, we know the mind setup of judge decides the fate of the matter. And this is accepted even in several judgments by Supreme Court also. The judge, his understanding of the law, his consideration of the law, and the matter put up by the advocates before him, that matters what is substantial question of law. And therefore, Madras High Court has very specifically stated that if a case is debatable, if case is arguable, if case make out a divergence of opinion, then it involves substantial question of law. Now, this is up to the lawyer, the advocate, the appellant to raise all these points and make out his case as debatable, arguable, considerable worth based on provisions of law. If a case of, yes, High Court judge has no discretion if the question of law is already settled by the higher court. If a question of law is settled by High Court, take example of now the debatable question all over India is what is the right of woman after the amendment of 2005? What is her share when notional partition opens? Then case of Prakash versus Fulvati came up. Then again there is a change in Supreme Court. Earlier it was open on the death of father. Then it is stated that no, as per Justice Lora's judgment, whenever the exception is carved out, that is registered partition documents. So now the question is still in the Supreme Court. Now this is a question which is not settled by the Supreme Court. It involves a substantial question of law. And all high courts now need to admit the second appeal as far as share of a party is concerned. When it is not settled by the any higher court, then it goes to the discretion of the court. And discretion of the court is circumscribed by the facts and circumstances of that case. You can't travel beyond the facts and circumstances of the case. And therefore, exactly, it is within a discretion of the High Court judge, the judge who is sitting and dealing with the second appeals. His perception to the facts and circumstances of a particular case, qua the rights of the parties and the decision taken by both the courts below, what is the inference, what is the impact of all these facts? If successfully it comes out, then the decision is decided on in that case with the discretion of the court. Discretion of the court is always judicious, based on sound judicial principles. That is what the Supreme Court and all courts expect.
Thank you, sir. The next question from our attendees is, proviso to subsection 5 of section 100 make more scope of, rather say, if there is any subsequent change in law which may change the view earlier taken or considered.
Yes. Subsection 5. Yes, it is always there. So that's why I'm saying that section 100 in amended provision opens more floodgates than to prior one. Prior one already only 3 grounds. Now it is within the discretion of the court, and subsection 5 deals that if at the time of hearing of second appeal, if High Court feels or satisfies himself that more other substantial question of law is involved, then High Court has every right to deal with those substantial question of law. And the question is rightly, qua the explanation just now I have given of the share of daughters with the amending provisions of law, and it goes on fluctuating. So at the time of deciding the final decision of the matter, the law which was in existence, that would be made applicable, and that is what subsection 5 says to that.
Thank you, sir. Our next question is, how should advocates understand or make out substantial question of law while drafting second appeal?
That's exactly. If you read these two judgments, which I just pointed out, the Privy Council and this, you have to find out that what your case is and how was the approach of lower appellate court to your pleadings and your evidence as considered with the evidence and pleadings of defendants. And if you feel that the application of my approach of the learned lower appellate court or a trial court is contrary to the law in existence, contrary to general law laid down by the higher courts, or even contrary to the proved facts. You might have proved a particular fact that yes, you are owner on the basis of A, B, C document, but despite that, the court does not admit your documents, then interpretation of document, construction of document, all these are substantial questions of law. And you will find all of a discussion of all these questions of law in these two judgments, or even decision of Santosh Hazari case, that how it is drafted. Because obligation is now, as per amended provision, is cast on the advocate who drafts the appeal memo. According to me, if we read subsection 3 thereafter, then it is the High Court who should satisfy himself. So even according to me, it's of course a debatable question in a court. According to me, even if argument we raise a question of law as a substantial question of law, and we satisfy the court that it is a substantial question of law, then as per subsection 3 of section 100, the court can formulate that substantial question of law. So that is what how we need to draft our second appeal.
Thank you, sir. The next question is, when we file second appeal, grounds are to be pleaded in second appeal memo, or what is substantial question of law? Is the matter is to be pleaded in the second appeal?
If we see section 100 and section 96, your appeal memo should consist of only grounds. That is what section 96 says. As far as second appeal is concerned, you need only to draft substantial questions of law. The grounds are not necessary to be formulated or to be drafted in appeal memo. But in a practice, as we accept it from the old generation and we pass it on to new generation, and even we adopt it, drafting of grounds is for argument purpose. That where have you raised this? What have you stated in your appeal memo? So there should be some disclosure of facts. Therefore, we draft the grounds. But basic requirement of drafting of second appeal is only substantial question of law. If your appeal memo says that being aggrieved by this judgment, I am filing this second appeal which involves following substantial question of law. Question 1, question 2, question 3. There should not be multiplication of one ground in other grounds. Even in the practice, we observe that once a matter is admitted, the order of the learned High Court, Honorable High Court, speaks only of ground that this is a substantial question of law. So verbose drafting or several grounds drafting is not acceptable, not contemplative. It should be restricted, precise, and of a definite character. It helps the court also and the litigants also.
Thank you, sir. There is a lengthy question from one of our attendees. By decree of lower court, which was partly in favor of plaintiff about ownership and partly in favor of defendant, that is, his possession was protected. Only plaintiff filed first appeal challenging findings in favor of defendant. No cross appeal objections. First appeal, appellate court confirms decree, no change. Second appeal is filed by plaintiff only. Respondent appears and tries to support view of first appellate court and criticizes finding of title in favor of plaintiff. What would be scope of second appeal? Can question of title be gone into?
Question of title, if it is decided in favor of plaintiff and the other party, it is not, he has not gone, because there are two parties, plaintiff and defendant. And if both the parties have right to go in appeal, again, there are two decrees against each other, one in respect of title, one in respect of possession. And if a person denied of title goes in appeal, and the person who got possession but no title, if he doesn't go, then the second person who goes in a higher court has a right to argue the matter. A person must approach to higher court against the part of a decree which is not in his favor. And if he keeps silence, then he has no right to argue in high court of the part of a decree which he has not appealed from. The second aspect of this, in many of the matters, decree in operative part, there is nothing against, but in finding it is given, then he need not file an appeal in a higher court. He can be happy with the decree which is passed by the lower appellate court or a lower court.
Thank you, sir. So we have our next question, which is if on any point of view the appellant forgets to frame the substantial question of law during the pendency of appeal or during the filing of the appeal, and if the second appeal gets dismissed, whether the appellant can frame the substantial question of law in review petition.
Of course, he can, because his second appeal is on a substantial question of law, and section 100 does not say or doesn't give consequences that if there is no substantial question of law, then your appeal will be dismissed merely on that ground. On the contrary, subsection 3 provides, in fact, this has been answered in my lecture itself, that during the course of argument, you can convince the court that your argument, there is involvement of substantial question of law, and you can persuade the court that court should frame substantial question of law, and court has every right to frame substantial question of law. And in review, it depends on the fact what you argued at the time of first hearing, because it is your responsibility, at least even if not framed, that at least you should argue before the court that your case involves substantial question of law. And you can very well point out in review also that yes, this is the question, substantial question of law involved in your case.
Rightly answered, sir. Sir, we are almost done with all the questions, and you have almost covered all the complexities involved in second appeal in the session. Your answers to the questions were also very insightful, sir. Thank you so much. With your permission, sir, I would now like to conclude the session by proposing the vote of thanks.
Thank you very much to all.
I, on behalf of Lex Disclosure team, extend my sincere gratitude to Advocate Prashant Katneshwarkar, sir, for accepting our invitation at a short notice. Sir, you have explained and enlightened us on this complex topic in a clear and precise way. Also, key ingredients of second appeal, that is, what is substantial question of law, mixed question of facts and law, and what can be said to be substantial question of law have been explained by you in a simple and unambiguous way. Thank you so much, sir, for your valuable insights.
Thank you very much.
For our attendees, there is an important announcement that Lex Disclosure team is organizing its next webinar on this Saturday, that is 6th of June 2020 at 11 a.m. on the topic how to challenge constitutional validity of statutory provisions by advocate senior advocate Shri sir. We invite you all to attend our webinar. Thank you everyone. Have a good day.
Thank you very much.